Good morning. The Hearing Board of the South Coast Air Quality Management District is in session. Today is Tuesday, February 5th, 2019, and the time is just after 9 o'clock a.m. We are meeting in the Hearing Board room in Diamond Bar, and we have one matter on calendar today, and that is SCAQMD versus JACK Oil, Inc., case number 6119-2 for an order for abatement. And who is representing the executive officer this morning?
Good morning, board members. Nicholas Sanchez on behalf of the executive officer.
Good morning, Mr. Sanchez. And who is representing JACK Oil?
Good morning.
If you can turn on your microphone.
Good morning. My name is Allison Wong. I'm a real estate attorney. I'm representing Amy Kim, who's here on behalf of JACK.
Thank you. And if you could just spell your name first and last for the record, the audio record, and for the record.
Sure. ALICENWONG.
Okay, thank you. Before we begin, I'm going to want to mark some documents that we received, but Mr. Sanchez, you had indicated that you wanted to address the board.
Yes, thank you, Madam Chair. The district entered into stipulated order for abatements against 4 retail gasoline dispensing facilities, all ARCO branded. Ms. Wong represents all 4 of those facilities. I will cover the first one today, JACK Oil. The other 3 are Surface, Nigrin Car, and Timeout. Nigrin Car has reached compliance. I requested to withdraw that matter last week from the board. Essentially, what's remaining to achieve compliance on these facilities is installation of the equipment that I'll present this morning, as well as passing of a performance test scheduled with the district. Some of those tests are scheduled towards the end of this week, which may achieve compliance for the Surface facility. So Ms. Wong had requested a continuance on this matter. I was not comfortable just because the allegations are that the compliance deadline for these facilities was in September of 2018. However, I indicated that she could present that to the board for them to determine whether that may be an option. Perhaps after hearing the matter today, the board should see that what the parties have stipulated to is very straightforward, but the district is a little hesitant just based upon the duration of noncompliance, and it is construction and anything can happen. We do have a firm date, and it is my inclination of having the comfort of having the facilities under an order if there is any deviations, but I just wanted to tee that up for the board to consider that there are besides this one, 2 remaining facilities with essentially identical facts to be determined by the board. Thank you.
Thank you. And Mr. Sanchez, is that your opening, or you'd like an opening on this particular
Oh, that was
matter?
just a preliminary matter, just to give the board an idea of what's going to be presented today, as well as the other similarly situated facilities. I'm sure the board picked up on the similarities, but just to reiterate that for the board's determination.
Thank you very much. So let's just begin by marking. There's a couple of new exhibits that the board should take a moment to review. So I'm going to mark all the exhibits we have, and then we'll take opening statements, and then the board will go off the hearing for just a few minutes to review whatever documents we have not had an opportunity to review. So we have received proposed findings and decision for stipulated order for abatement, and that was date stamped February 1st, and we're going to mark that as Exhibit 1. We also received declaration of Kirsten Melville in support of the proposed findings and decision in order for abatement, and that is also date stamped February 1st, and we're going to mark that as Exhibit number 2. And then we received what I believe is an exhibit for the respondent. Is that correct? Okay. It is a single-page document beginning info, Ray, the difference between vacuum assist and balance, and we're going to mark that as Exhibit A for respondent. And with that, I'm sorry. Oh, there was one. Oh, I didn't see that one more was being handed out. No. Oh, no, they just got handed out. Oh, yes. The proposed findings and decision were sent to us by email and also were in our box this morning. The declaration of Kirsten Melville is attached to it, and we're not sure if it was sent to us or not. It was not, thank you. And so we're going to review that in the time when we go off the record. We also received a stapled package of a few pages, starting with a map on the very top, and we will mark that as Exhibit B, as in boy. And I believe that's it for the exhibits. Do you have a question, Mr. Balagopoulos?
Yes, we did have in our inbox, I think last week, it was dated January 19th, on the petition for the order of abatement, and there were some documents attached to it. I thought they were relevant.
We don't normally need to, unless the parties ask us to, we don't need to mark them because they're part of a document that is in the record because it was a petition that was already put into the record, so we don't have to mark it
But
separately.
we can refer to it since
You
it's,
refer to it as the petition, and they are, I assume, I forget if they're numbered, they're lettered. So you would, if you wanted to refer to one or more, you would refer to the petition Exhibit A, Exhibit B, et cetera. That makes sense. Okay, with that, Mr. Sanchez, if you'd like to begin your opening.
Thank you, Madam Chair. Good morning, board members. The matter before the board today deals with the retail gas dispensing facility. There are other similar facilities that the district has also petitioned this board for similar relief through a stipulated order for abatement. These facilities are unique in that they are below ground, above grade storage tank facilities. So essentially the gas storage tanks are serviced or filled through a vault located at the facilities. Carb did not previously have a certified phase one, a certified system for these particular facilities. However, they did certify a system to meet phase one and phase two EVR requirements around September 2014. Once that certification process occurred, the facility was to upgrade their facilities. These type of facilities were to upgrade their systems by September 24th, 2018. This specific facility, JACK Oil, sought variance relief before this board, indicating they were unable to meet that deadline and petitioned in late September 2018. One of the reasons was that the location of the equipment which they had initially proposed to the Air Resources Board and to the district was not approved. However, due to them being on notice previously, the board determined that they could not make the good cause requirement and their petition was denied. Following that denial, the facility then sought a research and development permit from the Air Resources Board for their system, and that process began around September 20th, 2018. The district was included in that request, and the Air Resources Board approved the request, as well as for 3 additional facilities on September 25th, 2018. Based upon the facility's diligence in trying to purchase the equipment, seek permits from the corresponding fire department, and their obtaining of a similar permit from the district, they have been in ongoing operation at the facility. However, what's remaining is obtaining the permit from the San Bernardino County Fire Department, installing the equipment, and scheduling and passing a source test from the district. They have been acting expeditiously in doing so. Based upon that, the district is willing to enter into a stipulated order of abatement with the facility. The process for the research and development permit will require tracking of data reporting to the district. The district will relay that data to the Air Resources Board, and at the conclusion of that research and development period, the goal is that the Air Resources Board will approve the system, and it will become a permitted option for these type of facilities going forward. The other 3 facilities are also going through this identical process that'll be presented to the board today. This process is at a cost to the facility, and the district does not believe there will be significant excess emissions causing any health risk during the order for abatement period. Thank you.
Thank you, Mr. Sanchez. And you had mentioned in your opening that JACK Oil had come to this board requesting a variance relief. That was an ex parte, is that correct? Okay, just so if the board members were confused, that was just for the chair. And Ms. Wong, your opening, please.
My client, Amy Kim, represents JACK. JACK actually tried to install the Healy certified Phase 2 EVR, and she hired an installer in January of 2018. The installer went to her station and looked at her station, and realizing that her vents were on the canopy, recommended installing the canister for the Phase 2 EVR up on the canopy, because that would prevent having to do any trenching. So the installer hired someone to prepare the plans, Carbon Tech, which is an engineering firm. And Carbon Tech prepared the plans to put the canopy for the Healy, the certified Phase 2 EVR, up on the canopy. But, it took about 6 months for the installer to make arrangements to get the deposit from Ms. Kim, and then to give the deposit to the person who was to prepare the plans, and then for the person to actually prepare the plans. Took about 6 months. So the plans were submitted to the district in, I believe, July to proceed with the certified equipment, install the certified equipment. But then during the plan check process, it turned out that the canister couldn't go up on the canopy. And the person who prepared the plans and the installer were both very confused about this, because they thought they had seen another facility with the canister up on the canopy. But the district said, no, apparently it's dangerous for the inspector to have to climb up on the canopy to look at the canister. So by that time, it was early September, I think like September 20th. And that's when the person who prepared the plans came forward to the board for the ex parte variance to get more time to figure out how to take the canister, what would require the least amount of trenching to put the canister in another location, not on the canopy. But because JACK was subject to the September 24th, 2018 deadline to install the Phase 2 EVR, the variance was denied. So part of our problem is that there are 4 vaulted systems in the Inland Empire, and these above ground, below grade vaulted systems are unique. There's only 4 of them. Well, I think there might be 5, but there's 4 of them in the Ontario Riverside County. And it's very hard for other people to understand the plan preparer and the installer, because there's only 4. They don't understand how important the September 24th, 2018 deadline was. So that's part of our problem. And Ms. Kim actually tried to comply for JACK by installing the Healy. But because of the trenching issue and the vents on the canopy, that wasn't successful. But by the time they realized it wasn't going to work, it was so close to the September 24th deadline. And that's what brings us here today. So Ms. Kim decided to participate with the other 3 stations in this. So now we have 4 stations that are participating in a research and development effort with Carb. So basically, she started out trying to install the certified Healy Phase 2 EVR, but she wasn't able to install it up on the canopy because of the venting and the trenching issue. So now she has decided to join with 3 other station owners who are proposing to go through the Carb certification process through this research and development letter. And the good news is that San Bernardino County, which is the CUPA, which was previously taking up to 8 months to plan check and approve plans, through kind of our diligence in calling them, we didn't want to harass them, but we called them again and again. They finally, in a 3-month period of time, approved the plans. We just recently got the plans approved. The installer's ready to go. Ms. Kim had to return all of her Healy dispensers. When it turned out she couldn't install the canister up on the canopy, she had to return all the Healy dispensers, and now she's swapped them out for the Vita-Root dispensers, and installation is supposed to start on Monday, and the performance test is scheduled for February 21st. So we've done everything we could to bring it into compliance as quickly as possible.
Thank you, Ms. Wong. I don't want to interrupt you if you have more to say, but at this time, we're just doing a brief opening, so anything that you have now stated, Ms. Kim would have to state as evidence, just to be clear.
Oh, I'm so sorry.
Okay, no, that's fine. Do you have anything else in your opening? I had one question for you, and that is, you keep referring to Ms. Kim and that you represent Ms. Kim. Ms. Kim represents JACK Oil, is that correct?
Yes.
Okay, well, and so we'll ask you that then once you actually testify, once you're under oath. And so in fact, you represent JACK Oil today?
I do, but Ms. Kim is here on their behalf.
Okay, thank you. Just wanted to make sure that that's clear for the record. At this time, we're going to go off the record for a few moments. We're going to review the respondent witnesses that we received this morning and also the declaration of Ms. Melville. We're off the record probably for about 5 to 10 minutes. We're off the record. We are back on the record. You know, I neglected to ask Ms. Wong, you have not been before this board before?
No, I think you might be able to tell that, right?
That's fine. I just wanted to make sure. It was probably neglectful on my part not to explain the process so that you're prepared for that. So first of all, you're before the board today for an order for abatement that is stipulated. And so as a result, we begin with the petitioner, the district. And so I'm going to go to the district first to present any witnesses that the district may have, ask questions of the witness. Then I'm going to come to you. If you have any questions for their witnesses, you may ask at that time. And then the board will also ask questions of witnesses. When we're done with the district, and the district has presented all evidence and witnesses, we will then move to you for you to present any witnesses or evidence. I know you put 2 documents in the record. You can discuss them at that time. And then, of course, we'll go to the district to ask any questions of your witness or witnesses, and the board will also ask questions at that time. And then we're going to deliberate and make a decision today. I just wanted to also be clear, just so that I know that you had mentioned, and there has been mention of a request for a variance in the past. Just at this point, we are here to determine whether to grant the order for abatement that's before us. And so while you may present any evidence you wish, and any testimony that you wish, the more relevant question for this board is whether there is good cause at this point moving forward to issue this order for abatement, and will it bring JACK Oil into compliance as quickly as possible, is really the relevant issue at this point. So I'm going to ask, well, first, do you have any questions before we move forward?
No.
Okay. I'm going to ask anyone who may testify, including any public witnesses, to please rise to be sworn in at this time. Please raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God? Yes. Thank you. Mr. Sanchez, I know that Ms. Melville you've introduced as what is exhibit, what did we mark it? 2, the declaration of Ms. Melville. Would you like to introduce Ms. Melville, and if you have any other questions for her? Otherwise, we'll see if anyone else has questions.
Okay, great. I'll just ask some brief follow-up questions. The district would like to call Kirsten Melville. Ms. Melville, can you please state and spell your name for the record?
Kirsten Melville, KIERSTENMELVILLE.
Did you take the oath this morning?
Yes, I did.
Are you employed at the South Coast Air Quality Management District?
Yes, I am.
And what is your position at the district?
Air Quality Analysis and Compliance Supervisor.
And how long have you been employed at the district?
11 years.
I'd like to show you what's been marked as Exhibit 2. Do you recognize that document?
Yes, I do.
Did you prepare it?
Yes, I did.
I had mentioned in my opening statement about the unique type of facility that JACK Oil has, a above-ground, below-grade storage tank. Are you familiar with the configuration at that facility?
Yes, I am.
Can you please give us a brief description of the equipment?
The equipment at the facility consists of 3 vaulted above-ground, below-grade storage tanks with 12 nozzles dispensing 36 products.
And is this normal compared to what you would normally see at a gas station, and how gas is received and dispensed within the district's jurisdiction?
This is not a typical configuration, and as such, Carb, the California Air Resources Board, had issued site-specific certifications for these unique facilities.
And so I had mentioned the deadline in which these facilities were to comply with of September 24, 2018, or were you familiar with that deadline?
Yes, I am.
And once this facility passed that deadline, what was the original proposal of the type of equipment that they were going to install?
Carb had only certified one system for this configuration, which would be considered an assist Phase 2 EVR system. So prior to the September 24th deadline, that's all that was available to them, and to be in compliance, they would have been able to only install that configuration.
And do you have an understanding of why they didn't proceed down that path?
Yes, in this case, the facility requested to put the clean air separator, which would be the processor for the Phase 2 system, on top of the canopy. And unfortunately, in the installation, operation, and maintenance manual of the executive order, that particular installation option is not possible.
I'm sorry. Senator, you are pointing at the declaration, and you're asking what it was marked? Sorry, that is exhibit number 1. So I'm so sorry. I did not intend to disrupt your testimony. Please continue.
That's okay.
And when you say canopy, I know you had explained to me what that is. What is the canopy at a gas station?
The canopy at a gas station is basically what you would consider like a patio cover, which covers the dispensing area for the vehicles.
Okay. And so once that installation of the equipment was denied by the Air Resources Board, what steps, if any, did the facility take to try to find an alternative path?
At the time, because they were informed they could not install the clean air separator on the canopy, they attempted to file an emergency ex parte variance to seek relief from the upcoming deadline.
And is it your understanding that that relief was denied?
Yes.
And what was the next step they took?
The next step they took was to contact the Air Resources Board to see if there was an option to go with the balance system, a currently uncertified system, and go through a research and development process.
First, can you explain what that system is?
So a balance system would allow them to not have what is considered more of an active system like the assist system, which is pulling vapors out of the car. A balance system relies on the natural pressure differences. So as you dispense fuel into a vehicle, the displaced vapor goes back into the underground storage tank just on the pressure variation there. So there's that would differ from the assist system, which has an active vacuum that's pulling the vapors out of the vehicle and returning it to the underground storage tank.
And the point of all these systems is to recover the vapor that's within the tank when gas is dispensed?
The point of these systems is, yes, twofold: to collect the vapors during the actual dispensing process with vehicles, as well as the delivery process when gasoline is delivered to the station.
And what was the decision from Carb regarding that request?
Carb granted a research and development letter for the facility.
And did the district participate in that process?
Yes, once the district received that and the facility applied, the district issued a research and development permit for the facility on, I believe it was October 16th, 2018.
And what's involved in the research and development process for these type of permits?
So in this case, we give the facility some time to install the currently uncertified equipment, and then they will go through some initial testing to decide which of these sites will meet the criteria to be able to be included in the Carb certification process. So once a site is selected and sealed by the Air Resources Board, then they'll go through a testing period to determine whether or not they meet the certification requirements in the I believe this would go under CP 201.
And does the facility report that data to the district?
The facility will report the data both to the Air Resources Board and to the district.
And does the district stand in the role of the Air Resources Board as the local monitor over compliance with the research and development permit?
We do.
And what is your understanding of the status of the installation of this equipment at JACK Oil?
I believe they're going to be starting installation.
And so what is the path once, what do they need to do to achieve compliance with the permit and be operating in compliance?
They would need to install the equipment and within 10 days after initial dispensing, conduct performance testing and pass.
And is that something they schedule with the district and district staff is on site to observe that testing?
Yes, the district requires 72-hour notice prior to testing.
I'd like to show you what's been marked as Exhibit 1, starting on page 5, the conditions and increments of progress proposed by, stipulated by the district and the facility. Are you familiar with those conditions?
Yes, I am.
And did you help develop them?
Yes, I did.
I'd like to show you Exhibit paragraph 4, sub A, what is intended by that condition under the order?
I believe it's just to advise us on whether or not they encounter any problems during installation, and if so, I think we'd have to come to agreement on whether or not they're going to be able to continue with this particular type of equipment selection, or if they'd have to revert back to what's currently certified.
And so going to condition 6, what does that condition contemplate following what you just described?
This would mean that out of the other potential facilities, they identified the one that would meet there's, a minimum throughput requirement that the state requires for all certification sites. So they would see, which site is operating, getting good data, and meeting the certification requirements. Once that's determined, then they have to submit an actual application to the Air Resources Board for certification of this new system.
And so is there currently a fixed deadline in which they need to complete all this research and development through the Air Resources Board and the district's permit?
Yes, the deadline for both of those permits would be June 30th, 2019.
Okay. And then going last to condition 7, what is the district seeking with that condition if this research and development process is unsuccessful?
Essentially, I believe the intent of that would be that since the process would be unsuccessful, they would have to revert back to a different system, so they would need to submit, again, permits to the other agencies as well as us to identify the new system that they would be moving to.
And would that essentially be the existing, for lack of a better term, standard vapor control system located at most gas dispensing facilities in the district?
They would be having to revert back to the assist system, correct?
Okay. Thank you. No further questions.
Thank you. Ms. Wong, do you have any questions for Ms. Melville?
Is the current condition 7 drafted in such a way that if the Carb certification isn't completed, that JACK would have adequate time to submit the permits to San Bernardino Fire and to City of Ontario for the assist?
My interpretation of the condition would be that if the R&D letter is not currently extended, then yes, we would be giving you 30 days from notification by the Air Resources Board that you would need to submit applications to the other agencies.
30 days to submit the application, but not 30 days to remove the equipment. Because it's typically taking 90 days to process. I just want to make sure no one expects the Carb certification to fail.
I think the
But
intent is just to submit the applications. We're just saying within 30 days of being notified that you need to, remove the equipment, you need to submit the applications to the other agencies.
Okay, so there's no deadline to actually remove the equipment. It depends on how long it would take the agencies to permit the Healy.
Based on that wording in that condition, it's just to submit applications.
Thank you.
I'm sorry, was your question regarding removal of equipment? Because is that the same as condition 8? Was that your question?
I just wanted to make sure we have plenty of time for permitting because it's been taking a really long time for San Bernardino Fire to process plan check. And we need, in the station.
Why don't we wait for testimony on anything?
It's my understanding in the past that Carb will actually set a deadline for you to remove the equipment. They'll identify in a letter to you that says, effective X number of days from the date of this letter, you no longer are covered under the R&D protection, and you would need to remove the equipment by that date. But we, as the district, I don't have control over what Carb sets in terms of that time frame.
And is that why Condition 8 is worded within 10 days of the notice from Carb unless directed otherwise by Carb?
Correct.
Okay. And your understanding of that is if a longer time frame is given by Carb, that longer time frame would prevail, as well as if a shorter time frame were given by Carb?
Correct.
Okay. Mr. Wong, Ms. Wong, did you have any other questions?
No, thank you.
Okay. I had a couple of questions, and I think Mr. Balagopalan does too. I want to understand if, well, first of all, we need to set a date by which this board continues to have jurisdiction. So I wanted to understand how long this might go. And you took me a little bit along those lines, but I want to be very clear on a couple of things. In condition number 6, it says respondent shall submit an application to CARB for certification of the balance system, blah, blah, by no later than April 1st, 2019. Why is that date chosen? And in particular, I want to be clear, because I had the question, how long does the R&D permit last? I thought you said June 30th. So if you could explain if I'm correct on that and why April 1st.
Sure. So CARB did set an expiration date for the R&D letter as June 30th. I think the district as well as CARB is looking for good faith in terms of them actually proceeding down the certification path. So there's two different parts. Right now, they're given an R&D letter to test this new system. It would be unique for this type of configuration, but at the same time, they also want to see that they're actually going to move forward and certify the system. So we'd like to see an application ahead of the expiration date, and that way, if they're going down the path and they need a little more time, then CARB would feel comfortable in granting the extension to the R&D letter, which the district would do correspondingly as well.
Thank you. Makes sense. And then, first of all, I was very pleased. Thank you very much for being so thorough, both you and Mr. Sanchez, in including, should this not work out, moving forward with the other technology that is already certified. And the question is, so in the event the letter is not extended, is that a different, now I'm looking at condition 7, is the extension of the R&D letter something different than looking to certify the equipment through a permit?
Yes.
And how does that process work?
CARB, I'm not sure, has specific framework or policies in terms of granting extensions on the R&D letter. Again, I think they're just looking to see that they're actually moving towards certifying the system. They don't want to keep granting R&D letters if nobody's going to continue down the actual process.
Mm-hmm. So that R&D letter could very well be extended past June 30th?
Absolutely.
Okay. And so that would put out this particular condition a long time. Do you have any, and you may not, do you have any idea how long possibly this process could take?
Certification itself can take a long time, just because there's a lot of criteria that are met through, again, they're following the certification procedure, CP201. CARB is. And so, they have to have a certain number of observations of the nozzles, collecting spillage, collecting pressure data. It's a longer process in that sense. So certification will definitely go beyond the current expiration date of the R&D letter.
Okay. Do you think it would be, if we were to choose a date, which always could be extended later, but to hold jurisdiction, would a year make sense in the time frame based on your experience and knowledge in this area?
I think so.
Okay. And one other question, and that is, just to be clear, the approval of this R&D letter for JACK Oil in particular, that is, to your knowledge, attached as Exhibit C to the petition in this matter?
Yes.
Thank you. Mr. Balagopalan had questions, and then Ms. Byrd.
Yes, Ms. Melville. Referring to that letter in Exhibit C, can you bring that up? Can you, because I'm a little confused on the date.
Yes, thank you for pointing that out. I did make copies and forgot to distribute them. If we can go off the record, I do have an updated letter.
Oh, okay.
Okay, I think then let's go off the record and get copies of that. Thank you for pointing that out. We're back on the record, and we just received another letter, a second letter from with the letterhead California Air Resources Board dated December 18th, 2018, and we will mark that as Exhibit 3. And Ms. Melville, if you could introduce that for us, explain what that is.
Yeah, so initially, the Air Resources Board did grant an R&D letter that had an expiration date of December 31st, 2018. And once they, again, found good faith that the station owners and operators had moved forward with applying for permits with the CUPA and were proceeding to do some contracts in terms of installation, they felt comfortable in extending the R&D letter through the June 30th, 2019 timeframe. That's condition, I guess you would call it condition number 8 of the revised R&D letter with a date of December 18th, 2018 from Carb on page 4.
Thank you. Mr. Balagopalan, you had additional questions?
Yeah, actually, I'm confused because the original letter that Carb sent, the expiration date was 2019, not 2018, right? Because it said Carb approval shall expire on December 31st, 2019.
So then they sent another one and revised that because
the
they
one we got just now,
yes.
which is even, it says have a December 31st expiration date.
Yes, and then if you look further, if you look on page 4, I believe it's number 8 there, it should try to clarify, and the expiration dates were clarified to the district and to the station owners via email. There was a typo initially on the first letter stating 2019.
Okay. Now, do they have to do phase 1 and phase 2 testing?
Yes, so phase 2 only works in conjunction with phase 1. So in addition to doing a phase 2 upgrade, they're also doing a phase 1 upgrade.
So they haven't not done any yet, right? I mean, they have not installed the new system and done the testing.
For this station, correct?
Now, phase 1 testing, if I'm not mistaken, needs to be done over the summer
No.
with the high temperature, for the, because this is AST tanks.
Yeah, so in some districts and some other areas of the state, they have certain requirements in terms of the time of day that you can test. The district here does not restrict any of that testing.
Okay. Back, can you explain what's the difference between an underground storage tank versus a above ground, below grade? What's it?
So an underground storage tank would be a tank that's direct buried into the ground. So it'd be surrounded or backfilled with dirt or rock or other material. In this case, if you can imagine an above ground storage tank, they have a vault instead. So they're putting the tank inside of a vault as opposed to direct burying it into the ground. So there is access through like a ladder that'll bring you down, and then you can do, like a visual inspection of the tank underground and whatnot. So you have access to all portions of the tank.
So it's below grade, but it's in a vault. So
Yes.
and it's not backfill compared to an underground.
Correct.
And that's the essential difference.
Yes.
So then, for all purposes, it's classified as a above-ground tank.
Yes, it's a vaulted, above-ground,
Below
below-grade tank
Tank,
to make it more complicated.
yeah. Then I noticed that in the condition and in the violation of the rule, it cited 461C1 A, which is for underground storage tank, instead of C1B, which is for above ground. Do you know why?
Because we're calling it a below-grade tank, we're considering it to be in the underground storage tank, and that's what Carb has done. So the currently certified system for a vaulted tank would be under VR 202, which is traditionally considered an underground storage tank executive order.
Okay. So it's not,
It's not considered an AST or an above-ground storage tank by the district or by Carb.
but every advisory calls it a above-ground storage tank.
Yeah, in terms of the technicality of what the actual physical equipment is, but it is considered and it is going through the certification procedure of a traditional underground storage tank.
So then C1B will only apply to the actual ones that's above grade?
Correct.
And not the one below grade?
Yes.
Okay. The testing that they have to do, okay, I'm sorry. The Old Castle, that's the make of the vault, is it, or the
tank.
The tank, and it's in the vault, basically.
Yes.
It's a single, what do you call it?
Single wall?
Single wall tank in
Sure.
the wall. Now, and they're going to remove, are they going to, with the balance system, are they going to keep the same
Yes.
tank, but just upgrade the, to a balance system?
Yes, so they'll do, in this case, they're upgrading to a VR 102, which is the Phase 1 system, so it's an OPW. So that's mainly going to consist of the drop tube and the vapor poppet and the vapor adapter. So they're upgrading essentially on the dispensing, the fuel delivery side. So that'll be that upgrade. And then the Phase 2 side will be the balance hanging hardware with the carbon canister.
Now, in the ARB's letter, though, they didn't, in the table 1 of the, and let me look at the more recent letter, if they, because the Phase 1 and Phase 2 components, the steel wall, the manufacturer, they referred to somebody else. Is the Bambexino, if you look at table 3 of the letter?
Sure.
Is that the same manufacturer of the existing tank, or? Because they seem to refer to a different, because if I look further, they say they have to remove, and I saw it in the old letter, and I haven't read completely to see the, so in page 2 of that letter, they say, B, remove any existing underground, any dispensing equipment, including underground piping, dispenser, vapor recovery, to upgrade to currently certified EVR system. And I know their system is not certified, so that's what they're going through. So does that mean they don't have to go through one of those items listed in table 3, or?
I believe the intent, while they may have listed a different tank manufacturer, is to allow them to keep the existing tanks and then just to remove the vapor recovery piping that's associated with the current system and upgrade.
And as long as the test shows that they can meet those performance standards for both Phase 1 and Phase 2, then ARB will potentially certify them.
Correct.
Okay. Now, the district has issued the R&D permit?
Yes.
So it's for the same tank, basically, with the, so what's the essential, what is in the R&D permit that will enable them to move forward?
So essentially, yes, our R&D permit does specify their current tank system, and then it basically describes what would be the new executive order for a balance system, which would be VR 204. So it's that in addition to the VR 102 for the phase 1 side, and then they're also operating with the Vita-Root vapor polisher, which we consider the carbon canister. So that's the equipment that's described on our permit.
And so the vapor polisher doesn't have to be above the canopy anyway, it can be down someplace?
It's affixed usually right onto the, where the vent pipes are.
Now, in the event that they don't get the certification or the test fails and they don't meet the specification, they have to go back to the old vacuum assisted system, right?
Correct.
And then that would require again the polisher, I mean, the vapor system.
Cleaner separator.
Cleaner separator, which they couldn't get space to put it on. Where would they then, where would they be then in the event they don't pass the certification? And they have to revert back to the system, and they're back to where they didn't get approval, both from the district and from other, Carb, is it, for the, putting that on the canopy?
Yeah, so they would be at that, at that position that they would either have to do some additional construction to be able to find a place to put the clean air separator. The manufacturer is actually the one that is holding firm in terms of certification. They are not willing to go through the certification process, or I believe it's because of liability concerns to say that you can mount a clean air separator on a canopy. They require installation on a 2-inch slab of concrete. So the facility would have to find either a way to do construction or cease operation at the time.
Oh, is there an option for them to, for the facility to go with a certified system? That ARB has certified ASD above, below grade phase 1 and phase 2 systems that they could potentially.
There's only 2 systems. So there's the currently certified assist system with the clean air separator, which due to their unique configuration in terms of construction and room, they don't have room for the clean air separator. So then the other only option is a balance system. Other than that, they would have to, I guess, potentially seek certification for an entirely new system that hasn't gone through any kind of certification prior to that.
Okay. Yeah, that's all I have for the.
When I read this and the underground, I'm familiar with underground storage tanks. I'm familiar with above ground storage tanks. This type of configuration is, what is your understanding of why it's used? Do you have?
My understanding was that at the time of installation, there was some tax incentives through Board of Equalization.
Oh, okay, to have an above ground storage tank in a vault.
Yeah, that's my general understanding, but these
Okay.
vaults are all pretty old.
Okay, I was planning to ask the respondent also, but I was just wondering if you, okay. And then I believe either in Mr. Sanchez's opening or a combination of both openings, there was mention of 3 things that needed to happen: the fire permit from the CUPA, from San Bernardino CUPA. And are you aware of, and I'm not sure who said it, if it's true that the plans were recently approved by the CUPA?
My understanding is that, yes.
Okay, and you're aware then that the installation will also be beginning next week on Monday?
Yes.
And that there has been a date already set for the source test? Or I mean for the, there's already a date set for testing and the district's been notified of that?
I'm not sure that the district has been notified of that testing date yet.
Okay.
It's an automated system, so essentially I'll
okay.
get an email advising if they've met the timing requirements.
Okay, I'll ask okay, thank you.
Any other questions? Senator?
Clean air separator cannot be installed in the canopy because of the safety factor.
That's my understanding.
Is it possible for someone to apply for a waiver or exemption from the Carb, given the fact that this is not safe to be installed in that location, and make it a grade level?
The manufacturer would have to go through the certification process, so all of the districts adhere to only what is currently listed in the installation, operation, and maintenance manual, which is part of the executive order, so they'd have to go through certification for that.
So the installation manual can be modified if it's approved by Carb, is that not correct?
If they go through the certification
They
procedure, yes.
should be requested based on the fact that it's not safe, not determined to be safe by the manufacturer when you install it above on the canopy. It seemed like to me that's the way to go.
Well, it's currently certified to be installed on the ground only on a 2-inch slab of concrete, and so they are not willing to go through the certification procedure to put it up on a canopy.
All right, okay, fine.
Yeah, just to add, basically, it's when you only have a handful of facilities, there's a cost to the manufacturer to go through that certification process, and so it's basically a business decision that they haven't gone down that road, and so then,
Is it grade level underground?
The clean air separator is at grade level.
Okay.
Mr. Balagopalan?
In the Carb, in the revised Carb letter and also in the original letter, they did give 60 days to remove all uncertified equipment, but the district can be more stringent and, on that, but they gave them 60 days, and I think you heard, they may need, some time to remove the equipment and go backward to the new installation. So Carb did give them 60 days, and I think, what is the stipulated order giving, 30 days or?
I think we specified 10 days unless otherwise directed by Carb, so we're willing to go with whatever Carb's determination is on that time frame.
Condition, is it on 7? Let's see if that's the findings, says that respondent shall, if the event is not extended, remove it within 30 days of expiration of the Carb R&D letter, which is June 30th. So
I believe we're asking them within 30 days to submit applications to the other agencies.
Yes, condition 7 has to do with applications for permitting, and condition 8 has to do with removal. And there is at the very end, unless directed otherwise by Carb.
right. So 10 days seems, remove the equipment within 10 days of notice from Carb. Now, the Carb has already, in a sense, gave them the 60-day, unless the district wants a more stringent date. Did you expect them to give another notice after that? Oh, I mean, because in their letter, they said they remove everything within 60 days of expiration, of the expiration date. So they've already sort of indicated, but said the district can be more stringent. But we seem to be putting the burden back on Carb again, come with a new date. Is that your understanding what the sequence of events you want to occur, or?
I think my understanding is that we're willing to go with Carb's determination. If Carb extends the letter and gives a shorter time frame of 30 days, or if they extend the letter again and give 60 days, we're willing to go with what the Carb directive is.
But if they don't extend it and this order expires, this letter gives them 60 days. And the district's condition gives them how many days?
I think the intent of the condition, again, is that 10 days unless Carb directs them otherwise. If Carb's direction is 60 days, that we're willing to go with the 60 days.
Okay, so if they don't, it's not extended. Okay, so if it's not extended, which is what this memo assumes, right? I mean, this letter says, then they got 60 days to remove the equipment.
So just to recap, if it's either 10 days or if it's not extended, 60 days as is in the current letter, but if the letter is extended, and a different time frame is given by Carb, that time frame would rule. Is that correct?
Correct.
Does that make sense?
No, unless the extension is granted, they should remove everything within 60 days of the expiration date. So they were specific, if they don't extend it, they have 60 days to remove everything. And the district can be more stringent.
I believe that condition 8 takes care of all of that. Do you believe it needs to be reworded differently? Because I believe condition 8 makes it very clear it's 10 days, or if Carb has something different, and if the current letter is the one that survives, it would be 60 days.
Well, and I think and I think you heard from the petitioner and from maybe even Carb's letter that, 10-day may be a very aggressive time frame to do all that removal. So I'm just, that's, and ARB did grant about 60 days to do that, and I think you heard the petitioner saying it takes some time to do that. So I'm wondering if 10 days is, are they going to be back here if they can't do it within 10 days, I'm just,
Would you like to answer that? I don't think I should answer.
I would say, again, we're saying 10 days unless Carb is telling them something else. And in this case, Carb is telling them 60 days, so we're willing to go with 60 days. That was the intent of the language of unless directed otherwise by Carb on condition number 8. So as they're being directed otherwise in this case and giving 60 days, the district is comfortable with that.
And are you proposing any change to the wording? Because in my mind, that's very clear. But do you have any other?
I'm just wondering, you think 10 days is sufficient to do that?
Again, I would say I don't think we're giving them only 10 days. I would think under condition 8, we're giving them the current 60 days.
And that clearly is stated, I believe.
Remove the equipment within 10 days of notice from Carb. So,
Unless
Unless
otherwise.
otherwise
directed otherwise.
by Carb.
okay.
Wait, let me just, are you finished with your, Ms. Byrd?
I only wanted to clarify for myself then that this condition basically takes into account the fact that Carb may issue another letter.
Yes.
Okay, that's what I thought. Thank you.
Senator?
How many extensions have Carb granted so far?
1.
One. It's a research R&D project, correct? Research and development.
Correct.
And you don't know what you're going to discover along the way when you're trying to research and come up with a new idea, a new proposal. What do you think is the likelihood that if they can't meet the deadline, which has been established by Carb, 60 days, they will be granted another extension if requested? Good faith.
I believe they would, and just to clarify, this new system that they're going to is something that is currently installed and certified for traditional underground storage tanks. So I believe that Carb's belief is that since it works for underground storage tanks currently, they don't foresee many challenges, with it being installed in this unique configuration. So I believe that number 1, yes, as long as they're continuing through the certification process, Carb will issue a revised R&D letter as needed.
Thank you very much.
Mm-hmm.
I had one other question as to trying to figure out how long this order will last and our jurisdiction. Something to think about by the parties. Does it make sense to say that we would have jurisdiction until final compliance, which would mean certification, or 30 days following expiration of the R&D letter, which would essentially put you at the last condition in the row, and then it is what it is?
So just to give you a quick synopsis of certification, once the site is selected, everything is set to go, Carb will seal the site, and that testing will commence for 180 days. That's the minimum. So then if it goes through certification, then it'll go through review by the CAPCOA subcommittee, and then it'll go to Carb's board, be approved, and then it has to go to the Office of Administrative Law, and so for approval as well. So that time frame can take upwards of a year and a half, close to 2 years. So I'm not sure that the board wants to keep jurisdiction that long, but I think in terms of the district, once they complete certification, I think that, I'm not sure, I think we'd be comfortable with the facilities at that point.
So at that point, so you're thinking more along the lines of the year? Okay,
I think so.
makes more sense. Okay. Anyone else have any questions for Ms. Melville? I don't see any. Thank you very much for your testimony. Before we proceed, let's take a 15-minute break, and then, Mr. Sanchez, did you have any other witnesses you wish to present?
No, I just asked at this time that Exhibits 1, 2, and 3 be admitted in evidence.
Any objection, Ms. Wong? Exhibits 1, 2, and 3 are in evidence. And when we return, we will turn it over to Ms. Wong and, I assume, Ms. Kim. We are off the record. I didn't say it, but why don't we be back at 10:30? We are back on the record. Before we turn it over to Ms. Wong, Mr. Balagopalan just indicated he had one additional question for Ms. Melville.
Ms. Melville, just point of clarification. I think in your declaration, you cited the April 22nd, 2002 executive order. Do you have a copy of that in front of you, or?
The 2002 site-specific
2002.
certification?
Yeah.
I don't have a copy of that with me right
The
now.
only reason because I looked it up, and it says that specific one was actually in 2007. There was another one.
G70201B?
Yeah, to G70201-B, April 5th, 2007. It's specific for the old castle above ground, below grade fuel vault with vapor recovery and trench vapor return piping. The one in 2002 was for the phase 2 system, the Hertz certification and so forth that they issued. Anyway, it's just, I have a copy of it, so I did look it up.
I'd have to take a look at what you have to be
And
able to comment on.
it's not going to
I'm sorry.
affect anything in the order per se, just to get.
Do you wish to introduce it as a hearing board exhibit?
No,
Is it relevant
I would
to-
like Ms. Melville to look at it and see if it's maybe, just like we got two December 18th, the letter from ARB, one didn't supersede the other kind of deal, so maybe she can look at that and say, no, this is not.
Well, if she does so, then we would need to introduce it as a hearing board exhibit.
Okay.
Do you wish to have her do that and to introduce it?
If
Is
there's
it-
no objections, yes.
Well, there would be no objections, but we need to take the time to make copies.
Oh, everybody has to have a copy.
Everyone would have to have a copy. Okay, would you like to do that? Go off the record? Okay. We'll go off the record, and make copies, and introduce that as hearing board exhibit number 1. We're off the record.
Yeah.
Okay, we are back on the record, and we are going to mark as Hearing Board Exhibit 1, number 1, what we have received as a copy of Executive Order of the California Air Resources Board G-70-201-B. And I don't know if we want to give Ms. Melville a moment to look that over, or do you need a moment?
No, I don't need a moment. Yes, I think there's just a typo on the date in the declaration, so it should be April 5th, 2007.
Thank you. Okay, so in the declaration, it is referred to, just so we're all clear. Okay, so that's Exhibit 2, and it's referred to in which paragraph?
2?
2.
2. Okay, I see. Okay, so the date of 2002 is incorrect. It should be, it's a typo. It should be April 22nd, 2007.
April 5th,
Oh, sorry.
2007.
April 5th, 2007. So that should be on line 24. And so let's change, do we need to change that? Is that in the, I think more importantly, is it in the findings?
I don't think it is.
It's page 1 of Ms. Melville's declaration, which is Exhibit 2, line 24, paragraph number 2. So it is not in the, the date that is listed as April 22nd, 2002 should be April 5th, 2007. Just a correction to Ms. Melville's testimony based on a accidentally incorrect date. Okay. Did you have any other questions, Mr. Belagopalan? Okay. I just have one question. It's either for Mr. Sanchez or for Ms. Melville, but on page 4 of the order, there are 2 therefore clauses. I assume the second one you do not wish to have, or is there a reason why there are repetitive clauses?
Which line are you on page 4?
This is, I'm sorry, of the Exhibit 1, the proposed order. I don't know if I was clear on that. On line 20, there's a therefore with regard to cease and desisting, or in the alternative to comply with the conditions. And then there's the therefore clause. It starts on line 24, just to cease and desist.
The second paragraph can be eliminated. I think the first one's more clear. There's a typo.
Thank you very much. Okay, and if there are no other questions for Ms. Melville, we're going to move on to Ms. Wong to introduce Ms. Kim. And if you could, before you ask any questions, if you could have Ms. Kim state her name, spell it, state her title, and indicate for the record that you did take the oath today.
Madam Chair?
I'm sorry, Senator?
Was it the declaration that made it into evidence already?
It was.
Prior to the change?
That's okay. The change is being made. So the change will be made, and just make sure, Madam Clerk, that you got that change. Is that correct? Okay, thank you for that, Senator. Okay. Ms. Wong, Ms. Kim.
Good morning. My name is Amy Lee Kim, and that's AMYLEEKIM, and I am the CFO of JACK Oil, Inc., and I did take the oath this morning.
Thank you. Ms. Wong, do you have questions for Ms. Kim?
Ms. Kim, about what time, what date did you begin preparing to install the equipment in advance of the September 24th, 2018 deadline?
January, it was around January.
Early January. And what did you do to begin for that process?
I talked to TLM Eddie Martinez because he was doing the remodel for the inside of the store as well. And so he was giving me a proposal for the pumps.
So he was working with you on remodeling the convenience store, and so you approached him to change the dispensers, right?
Yes.
And then do you know what he did after that?
I wanted to do what I wanted to go with what AQMD recommended, so I just told him to give me. I wanted to go along with what AQMD wanted. So
That was the certified Healy
Yes.
Assist Phase 2 EVR.
yes,
Okay, so he gave you a proposal to install that,
yes,
and then did you order the dispensers at that time?
yes.
Okay, and then Eddie from TLM, the contractor, the installer, then what did he do?
He said he was going to contact his permit person, which was Greg Roberts with Carbon Tech, and that process.
To prepare plans?
Yes, that process started in May.
Okay, so May, your contractor went to his plan preparation company and told them to prepare plans to install the Carb certified Healy Phase 2 EVR. And do you know how long it took the plan preparation person to draw up the plans?
No, we were in conversation. Eddie said that it was being handled, so I just assumed that it was being handled.
And then you received a letter from the district reminding you of the September 24th,
Yes.
2018? When did you get that letter?
I believe it was in March.
And then do you know when Carbon Tech, the person who prepared the plans for the installation, do you know when they submitted the plans to the Air District to get the installation permit?
Late July.
Okay. And then do you know how long it took the Air District to review, approximately how long to review? Because late July, and then you knew you had the September 24th deadline.
Yes, and then Greg informed us that the canister couldn't go on the canopy around September 20th.
And do you remember when you first met with TLM, why he wanted to put the canister up on the canopy?
I don't remember the specific conversation, but that was the only area that he recommended.
Okay. I spoke with the person who prepared the plans, and that person, Greg Roberts from Carbon Tech, told me that the vent lines at Amy's station already are on the canopy. So,
Unless you want to take the oath, your testimony is not evidence, but it's helpful. Thank you.
so to avoid trenching, you wanted to the installer was proposing to put the canister up on the canopy. And then about what date did he find out that that was not going to be possible?
September 20th?
Okay, and so then what happened?
Then we started scrambling, and we asked for the variance, and then it got denied. So then I called you because you were going with the R&D already, and I didn't want to go that. I just wanted to go the route that would be the best for me and AQMD and just be in the good graces, and it just backfired. So yeah, that's what happened.
So here we are. So, and I think I've already discussed that, so I don't know you really want to hear this. But the good news is that as soon as you learned that you couldn't put the canister up on the canopy, then what happened?
What was the question again?
So we kind of had a sea change on September 20th when it became obvious that you couldn't put to your plan person and to the installer that the Air District wasn't going to allow you to install the canister up on the canopy. So then what happened?
September 23rd, we asked Carb for JACK to be part of the R&D site. They added us. And then on October 16th, the Air District issued a install permit, R&D.
For the R&D?
Yes.
And then the plan person drew up new plans. We submitted them to San Bernardino County and City of Ontario. The plans, here we go. What date were the plans issued?
The
Sorry,
plans
the
were
permit issued?
the plans were issued October 25th, and then
Submittal date?
yes, and then we got approval from Coupa on January 8th, and we're installing on Monday.
And then one thing you didn't mention that I think the board needs to know is that you actually suffered a bit of a loss because you had previously ordered all your new dispensers, assuming that the Healy, certified Healy Assist Phase 2 EVR dispensers. How many dispensers did you order, assuming you could put the canister on the canopy?
6.
You had to return them all?
Yes.
And then order a different configuration
Yes.
for the balance. So it's been quite expensive and administratively very burdensome. Granted, that's just the way it goes. when
Can
own a
you
business.
please just phrase it in the form of a question for the witness to answer?
So were you able to return the dispensers? the
No,
Healy dispensers?
I wasn't able to return them.
Were you able to work something out with the distributor?
Yes.
And when are you expecting to take delivery of the retrofitted dispensers?
Monday.
So then you'll be ready to begin
Yes.
construction Monday. And do you know how long it's going to take for them to construct?
10 days.
10 days. Okay. And do you know how many inspections County of San Bernardino Fire and City of Ontario are requiring? It's 2?
Oh, I'm not sure about
I
that.
think it's 2.
Okay.
And then do you know what day, I think your performance test is scheduled?
For the end of January 20th,
January 20th.
Yeah.
So
21st or 20th.
and at that point, you think you'll be in compliance with?
Yes, I'm going to do whatever it takes.
I'm sorry, can you repeat the date by which, January 20th,
Oh, I'm sorry,
2019?
February, sorry,
I'm sorry.
February.
Okay, please, if
Sorry
the
about
witness
that.
can answer, and if the witness does not know the answer to questions, please just state you don't know the answer. Thank you. Okay, so can you restate the date if you know it?
For the
Performance.
performance test, it's February 20th or 21st.
Yeah, I think 21st, I think.
I was just told
Again,
about it this
okay.
morning. I'm sorry.
To the best of your knowledge, Ms. Kim, who is testifying, what is the date?
February 21st, I believe.
February 21st.
Thank you. Any other questions, Ms. Wong? No. Mr. Sanchez, do you have questions for Ms. Kim?
Thank you, Madam Chair. Ms. Kim, did you have the opportunity to review what's been marked as Petitioner's Exhibit 1, the proposed findings?
Yes.
And I'd like to direct you what starts on page 5, the conditions and increments of progress. Is Jack Oil in agreement to comply with those conditions as part of the stipulated order for abatement?
Yes.
And what impacts, if any, would this gas dispensing facility incur if they were to have to close until the equipment is upgraded pursuant to the research and development permit?
Well, I would, it bears on my shoulders, but my family's, it's a family-run business. And then I have about 15 employees.
Do you need some time, Ms. Kim?
I'm sorry. About 15 employees. You know, we are very aggressive with our gas pricing, so we offer very good pricing for our customers. The gas station across the street is Mobile. They're about 20 to 40 cents higher per gallon. You know, mostly it's my employees, so.
Okay. So would there be impacts if you had to close prior to installing the upgraded equipment?
Yes.
And what would the impacts be?
Oh, 85% of my profit, just because 85% of the sales is from gasoline.
Thank you. No further questions.
Thank you.
Thank you. Board members, do you have any questions for Ms. Kim? Mr. Balagopalan?
Ms. Kim, now you mentioned it takes 10 days to do the new installation for the,
Yes.
will the station be not operating during the 10 days, or?
Yes, so initially what the plan was, we were going to, when we were remodeling the inside of the store, we were hoping that the gasoline part would have been done as well. That was in September, but we remodeled the inside of the store in September. We were shut down for about 2.5 weeks for that. So this 10 days, we're still gonna have the inside of the convenience part open, but the gasoline, which is a big chunk of what draws customers, would be closed.
Okay. In the order, there's a reference to permit number N31488, and you have a copy of that permit? I'm just wondering if is that the R&D permit, or is that what permit is that?
Can you let us know where you are finding that
I'm
reference?
sorry, in the order on page 4, line 26.
Oh, that has been deleted.
Oh, it's been deleted?
Yes.
Oh, well, earlier, yeah.
Yes. You're right. We never went through the deliberation and a motion,
Oh,
but,
okay,
but
that's right, okay. So okay, never mind then. Then the question is moved. Do you have, in the ARB's letter, I saw that they copy the Department of Food and Ag, and then the State Water Resources Board. Do you get inspections? Do you have to have buy-off from those agencies also before you finally get certified? Besides the Coupa, I know you have the Coupa, you're working with the Coupa and getting you the permit. Do you have other agencies that are involved in the certification process?
Yes.
Yes, the Carb has to go through circulation to the Department of Food and Agriculture, Forestry, Fire Protection, Industrial Relations, and State Water Resources Control. That'll be Carb.
Ms. Kim, do those folks from those agencies come to your facility also?
I don't believe so.
I'm not really sure about the answer to that question.
Okay.
perfect answer. Thank you. Do you have any other questions, Mr. Balagopalan? Anyone else have questions for Ms. Kim? Well, I had one question. Still yet to come up with a date for retaining jurisdiction, which means how long this order would last, and we would have jurisdiction to hear any modifications or any status or issues. The current proposal by myself would be essentially a year from today, which would be about February 4th, 2020, or final compliance. Should final compliance occur before that, you certainly wouldn't want an order lasting longer than that, whichever occurs first. I just want to make sure that that's something that you and Ms. Wong would agree to, since it's a stipulated order.
Yes, thank you.
Any other questions for Ms. Kim? Senator.
I was looking for the section in the petition where information was provided to respondents that they put on notice they had to comply by a certain date. And of course, the letter document was sent by mail, and the respondent refused to accept the mail. I did read that in here, sir. Refused to accept the mail.
Yeah, actually, Allison,
They hand delivered it to you. So you're not very, you weren't very cooperative.
actually, Allison told me about that yesterday, and we never received a letter, like a certified. I never refused a letter, but I'm not at the store all the time, and I'm not sure why my employees, because we always accept everything. I don't know what happened to that.
Was it eventually hand delivered to you?
Yes, they did.
Personally?
Yes.
And when you were told that they rejected the mail initially, what was your reaction to that?
I don't remember them saying that it was rejected. I just remember them delivering it.
They didn't accept it, they denied it, so they rejected receiving it.
Yeah, I don't, we never said no. I never did any of
You were
that.
not aware of it.
I'm sorry?
You were not aware of the denial to receive it.
No.
But then you subsequently learned that it was delivered, and somebody in your shop didn't accept it. Is that correct?
I don't know if anyone in my store would say no to that. That's why,
It's written here, it's a lot of reading, but I didn't read that.
yeah, I don't, my employees wouldn't, I'm not blaming the post office, but I don't know of anyone in my store that would decline a letter.
You just said that you were informed about that declining your letter yesterday.
She told me that that was something.
What was your reaction to that?
I was shocked.
All right.
Any other questions for Ms. Kim? Seeing none. Ms. Wong, did you have any other witnesses or evidence that you wish? We didn't have an opportunity, I know we marked exhibit, where are they? A one-page exhibit and exhibit B. Was there anything in these exhibits you wish to bring to the board's attention?
Exhibit B, the aerial, just shows the JACK station up above, 729 North Archibald, and then kitty corner to the JACK station is a mobile station. And I just wanted to bring to the board's attention, yesterday, I did a screenshot from Gas Buddy. The mobile charges $3.39 a gallon for gas, and the ARCO charges $2.94. So I just wanted to bring to your attention that, as support for the argument that it would hurt the neighborhood to close down the ARCO, because the mobile charges 40 cents more a gallon for gas, and the mobile is the next closest gas station. So I just wanted you to have some support for that statement that Ms. Kim made.
Thank you very much. Any questions about that or anything else before? Okay. Ms. Wong, anything else you'd like to submit at this time? Oh, Mr. Balagopalan.
Ms. Kim, I think a question Ms. Berg asked earlier was why did the facility go with the below-grade vault type system versus underground storage tank? Do you have any recollection why that was done?
No, because when we bought the store in 2002, it's actually interesting. We were going through buying the process. I didn't even know that my parents, my family, we didn't know anything about vaulted tanks. We just saw the sales of the store, and that's when Allison came into the picture when we first met, because we had to go into this thing about learning about the vaulted system when we were already 25% into the process. So I don't know why, but.
Okay, that's fine, thank you.
Ms. Byrd, have a question.
This is the only gasoline dispensing facility that you are owner of?
Yes.
Okay. And you purchased, had you ever had any prior to the purchase of this facility?
I did own another AMPM on Central and Schaefer,
Okay,
but we sold it.
okay. And that one, of course, did not have these types of tanks?
No, it didn't. And that was a completely different system, but I can't be a multi-site operator. It's just too much stress.
Thank you.
Any other questions? Okay. At this time, then, I'm going to ask if there's any member of the public who wishes to be heard on this matter. And seeing none, I'm going to turn it over to Mr. Sanchez for a closing.
Thank you, Madam Chair and board members. The evidence presented today shows that good cause exists to grant the stipulated order for abatement. This facility, although it did miss the deadline to upgrade his equipment on September 24th, 2018, and did seek variance relief to get an extension, it was unable to make that finding to the board previously. However, it did find another path. It kept the district apprised of its efforts to do so. It has agreed to an expeditious schedule to achieve compliance. It is subject to permitting from other facilities besides the district. It has demonstrated that it is committed to get those permits, purchase the equipment, and install the matters to subject itself to the research and development process set forth by the Air Resources Board. And if they are unable to do so, the district has also included conditions that they upgrade to the more stringent and currently commonplace EVR system that's in place at other facilities that would be at a substantial cost and modification to the existing equipment, but the facility has agreed to do so. With those conditions in place, the district asks that the board grant the stipulated order for abatement as proposed in Exhibit 1 with the changes that have been presented to the board today. Thank you.
Thank you. Ms. Wong, any closing you wish to make?
Just to reiterate that JACCK has, once they learned that they couldn't install the canister on the canopy, they took immediate action and have pushed San Bernardino County Fire and City of Ontario and worked in hand with the district to come into compliance as quickly as possible. And we think February 21st, 2018, they will be in compliance. So we ask you please to approve the abatement order.
You meant 2019.
Oh, 2019, I'm so sorry.
Thank you very much. Board members, anyone wish to begin? Ms. Bird?
I believe that we can find good cause. This is an individually owned gas station with a different configuration from the normal for as far as tanks go. I think testimony was that there are only 4 or 5 that may even exist in the district's area. And this facility did start at a point where they believed they could be in compliance by the date that it was required. However, as they went along, they found out that the district would not approve having placement on the canopy, and that changed everything for them. They had to immediately switch gears, and they have done a lot to do so. They ordered equipment early enough that they thought they would be able to use so that they could be in compliance. And when they found that they wouldn't be able to be in compliance, and they took a different route, the route of research and development, permits through Carb and subsequently approved by the district. At this time, they have been placed, the schedule in the order places them on track to possibly be in compliance by February 20th, 21st, after they pass, if they are successfully passing their performance test. And as was testified by Ms. Melville, Carb expects that they would, since they are pursuing a path that is commonly used for underground storage tanks anyway, so they expect that they will be able to pass. However, they have agreed if they do not pass, that they will they will follow the district's guidelines and not follow and come into compliance based on whatever the district has decided that they will have to do at that time. It's a family-run business. They expected that they would have this construction or all of these retrofits done at the time that they were already planning to have some construction done, which would have saved them considerably. At this time, it's going to be a loss for them to have to close while repairs or retrofits take place. They've already gone through their necessary approvals, received the equipment, plan to begin construction of it, takes about 10 days, and then go through the necessary inspections and then do the performance test. I think that based on the testimony that I've heard, that they have done what they could expect to have done within the time that was available to them, and I believe that we should grant this order for abatement.
Thank you. Anyone else wish to add? Mr. Balagopalan?
Yeah, full disclosure, I bought gas at this station a couple of times. It's on my way to the freeway, and I stopped there today too at the traffic light, and I could not see the above ground. I knew it was below grade, so it was there. I think, and I'm completely wrong, I think part of the reason may be nearby is a catchment basin for the city of over there, and you have a regional park over there, so maybe one of the reasons why they wanted it not buried underground and leaking and going to the water table and so forth. Maybe that's the reason. That's my theory, why they had it required above ground, but I could be wrong. But yeah, I think we can find good cause. I think the petition respondent took all the efforts once they found out that they could not do the install the unit on the canopy. Then they try to get a ex parte variance, and then actually did the right thing in getting in contact with the ARB and getting the R&D letter. So I think that set in motion the steps that they're under now. So I think we can find good cause to grant the the stipulated order.
Thank you. Anyone else wish to add to discussion? Senator?
Is your car an electric car?
It's hydrogen, but I have been there. I mean, not recently, but
Sounds like a big business to me. You got 15 employees, so you imagine quite big operation.
Yes, there's actually more apartments. Oh, I'm sorry.
No, it's
I'm
not your fault.
sorry.
It's not your fault. It's not your fault. We have closed that was more of a rhetorical, correct? I mean, we're in
Right.
deliberation.
You asked me for a comment. I just think, in the mobile station nearby, I mean, the point was made that it's good for the community. Well, it's good for every community if you buy it for less money, if you like ARCO instead of mobile. But I think they made a good faith effort to try and be in step with what's required of them, so I'll support it.
And I believe Ms. Kim was very credible, and I'm sorry that it was so emotional to testify in this matter in terms of the impacts to your employees and your station. However, I feel you've been very diligent in attempting to come into compliance. Not that you even need to for an order for abatement, but certainly you've moved it along quickly, and it looks like everyone believes that compliance will be achieved rather quickly. So with that, I agree with everything that's been stated and can find good cause as well. And if there are no other comments, anyone wish to make a motion? Ms. Byrd?
I will. In the matter of South Coast Air Quality Management District versus JACK Oil, Inc., case number 6119-2, I move that we issue this order for abatement with the conditions and increments of progress as described in Exhibit 1, with the following change. The second paragraph that begins, well, not the second paragraph, but the paragraph that begins on line 24 through 26 on page 4 is to be deleted. And on page 6, The date for jurisdiction over this matter will be ending on February 5th, 2020. And that completes my motion.
I'll second the motion, and I would ask whether you would like to have jurisdiction end on that date or final compliance, whichever occurs first, just in case they should come in compliance earlier.
That sounds good. Let's add that at number 10.
Okay.
It will be jurisdiction over this matter until February 5th, 2020, or until final compliance is reached, whichever comes first.
Any discussion on that motion? Seeing none, Senator, how do you vote?
Aye.
Dr. Lerner, how do you vote?
Yes.
Mr. Balagopalan, how do you vote?
Yes.
I vote yes. Ms.
Yes.
Byrd votes yes, and the motion passes 5-0. And thank you, and good luck, and thank you both for very good presentation, and thanks again to Mr. Sanchez and Ms. Melville for providing the declaration in advance. It always aids in the hearing running smoothly and quickly. The only other matter I would say, hearing board members, is just a reminder that tomorrow, one hearing had been taken off calendar previously, and the other has now been continued to February 12th, and so we have no matters tomorrow, and we'll be back on Thursday. Any other business, board members? Seeing none, we are adjourned. Thank you all.
So surface is on the 12th.